Well, the United States Supreme Court has declined to reinstate the Biden administration's latest plan to forgive student loan debt. An earlier plan from the White House would have wiped out more than $400 billion student debt and lowered payments for millions of other borrowers. But the Supreme Court rejected that plan last year. Today, the High Court refused to lift a sweeping block, a stay on the president's most recent student loan repayment plan, known as SAVE. This legal challenge was brought on by Republican-led states, and now there are questions about what this means for the 8 million borrowers who have already enrolled in this latest program. Former federal prosecutor Neama Rahmani joins me now for more on this. Neama, walk us through what today's order means, especially for those 8 million borrowers who signed up.
Well, Terry, today was a do-over because, like you said, the Supreme Court in its last term in June blocked President Biden's sweeping loan forgiveness plan. So this was a do-over. And instead of canceling the debt entirely, what the Biden administration and the Department of Justice tried to do is to put caps on student loan payments as a percentage of income and to shorten the window for cancellation or forgiveness. So slightly different plan, but really the result was the same. Now, different procedure, of course. In this case, the circuit court, which is right below the Supreme Court, issued an injunction putting the plan on hold. The Biden administration tried to go to the Supreme Court to get that injunction lifted. The justices said no. So now that case is going to have to work its way through the circuit court in the normal course. It still may make its way to the Supreme Court, but it will likely be after the November election.
You know, and Neama, it seems like the courts are sending a pretty clear message to this president, to any president, is you can't forgive this much student debt without the participation of Congress. Does that sound right to you?
That absolutely sounds right. And like you said, we're really seeing the dismantling of the administrative state by this Supreme Court. And it started during the pandemic with restrictions on evictions and requiring employers to either vaccinate their employees or test them. And the Supreme Court said, well, administrative agencies can't do that. Doesn't matter if you're the CDC or the Department of Education or some other administrative agency. Congress has to approve that. And of course, we saw the big decision at the end of the court's last term, which really got rid of Chevron deference. And Chevron deference, of course, was something that legal scholars had really, it was the law of the land for about 4 decades. And it said that absent some clear congressional law, if there's any ambiguity, then administrative agencies can fill in those gaps. But now the Supreme Court has said, no, no, no. We need express congressional approval if there's going to be sweeping regulations like this.
Yeah, trying to put a crimp on the actions of the executive, Democratic or Republican. Actually, we'll see how balanced it is if we next time we have a Republican president, maybe soon. Neama Rahmani, thanks for that explanation.